Who are the Ad Watchers? We are attorneys at the National Advertising Division of BBB National Programs, a team with over 50 years of experience investigating and resolving disputes over the accuracy of national advertising campaigns.
We don't just take ads at face value. We put them to the test. Why? Because advertising law can be simple, but it's the execution that's hard.
Welcome to the Ad Watchers, NAD's podcast that gives a view into how our organization reviews claims and applies advertising law. If you missed any of our previous episodes, don't forget to check them out later. They're available wherever you're listening to this.
It's our second episode of season 5, and we're marking another anniversary today, aren't we, Eric?
That's right, Annie. Last episode, we celebrated 5 years of the Ad Watchers, our humble little podcast. Today, we're talking about 5 years of NAD Fast Track Swift. NAD Fast Track Swift is a procedural option that meets the need for speed for when you are challenging claims in advertising. It's an expedited track appropriate where all claims are challenged, either express or implied, that raise a single well-defined issue and do not require the review of complex evidence or argument, such as clinical or technical testing. Fast Track Swift, the SWIFT stands for Single Well-Defined Issue Fast Track. So we have the snappy little acronym there to tell you what it's about. So you get a single issue, and that review can be expedited. A few of the procedural differences with Fast Track Swift. The opening letter, the challenge letter that the challenger submits to NAD, that's limited to 5 pages. Also, the advertiser's reply is limited to 5 pages and 5 exhibits for each of them. So if you are in Fast Track Swift, you have to be very economical and punchy. There is only one round of briefings. You get the opening letter from the challenger and then the reply, and that's it. You go right to meetings. The decisions are issued within 20 business days from when the challenge is commenced. A little filing tip: when you are filing a challenge in Fast Track Swift, NAD needs to get the filing fee in before it can commence the challenge. So make sure that's your ducks are in a row there if you are proceeding in Fast Track Swift. But Annie, we're not just looking backwards. We're not just going to give the basics about NAD Fast Track Swift, since it has been 5 years and many more practitioners are becoming familiar with it. But, Fast Track Swift is becoming more and more a part of NAD's present and will be a part of NAD's future. As we discussed in the last episode, there was a big increase in Swift filings in 2024. We've increased 3 times. We've had a 3-fold increase over the last 3 years. And many of the hot topics and trends we see at NAD show up in our Swift cases. But first, let's talk a little bit more about what inspired Fast Track Swift.
So Fast Track Swift was started in April 2020, so basically a pandemic baby. But it was created in order to keep up with the pace of marketing, right? There are certain issues that require immediate attention. And while NAD cases, are resolved within 4 to 6 months, which is certainly not a long period of time as compared to litigation, but certainly there are issues that really need to be resolved much more quickly. And so, you know, this track was set up in order to provide that service to the advertising community, and it really is a turbocharged process.
Yes, it's 20 business days from the commencement of the case to the decision, and we do mean 20 business days. We do really stick to that, and if you do have a case that is appropriate for Fast Track Swift, you will get that decision in 20 business days. But not every case is built for Swift. Parties do test the waters because it is an attractive option when you're filing a challenge. To have a decision rendered in such an expedited manner. So Parties, of course, want to, when challenging, see if they have a case that is appropriate for fast track. So they do test the waters, and we do get a lot of objections. And oftentimes we will determine that a case is not appropriate for fast track Swift because it will require review of complex evidence, or really does present multiple issues that will require consideration that won't allow a fair resolution of the case within 20 business days. So we do look at it from that perspective. We do understand that an advertiser who participates in Fast Track Swift, may think they have a disadvantage because they're having to proceed on such an expedited basis. So we are very careful to make sure that the case can be adjudicated within the 20 business day timeframe, and with the procedural limitations in Fast Track Swift, such as the shorter submissions. So we make sure that it can be the case can be heard fairly in Swift. And one of the things we've noticed over the years, now that we have 5 years of cases, the cases, as we'll talk about a little later, they are not always the easy takedowns, let's say, that may have been envisioned when the Swift process was conceived. Sometimes we do get those where there is a material connection disclosure issue where the an influencer forgot to or didn't make the appropriate material connection disclosure, and that's a very straightforward case, or there's a case of a claim that is almost impossible to be supported, and that is very much subject to challenge. We get some of those, but for the most part, they present the very contentious, very intense issues and important issues that you would see in our standard track. And these are claims that are significant in the marketplace often, and because they are significant, challengers want them heard quickly. One procedural difference, for the practitioners out there, parties get the decision at the same time. So normally in a standard track case, NAD first gives a copy of the decision to the advertiser before sharing it with the challenger. Here it goes a little faster. Both parties get it at the same time, and we do look even faster here for compliance. You know, and sometimes we do have parties who disagree with our decisions. And Annie's going to talk about that a little bit more. But Swift decisions are subject to appeal at the NARB.
Yes, parties do have a right to appeal SWIFT cases to the NARB, similar to appeals in standard cases. But it goes faster, as you might expect, because it's a fast track SWIFT. So there are three panelists in fast track SWIFT appeals, and the parties have 8 business days instead of 10 to submit their briefs. Also, there's no right to a cross appeal in fast track Swift appeals.
So those appeals do get heard very quickly. Even a case that gets appealed, you can expect a quick resolution. So it doesn't really diminish the overall time in which the case is heard just because of an appeal by all that much. We get the 20 business days, we issue our decision, and then it goes to an appeals process that does work quickly. So just because there's an appeal doesn't necessarily mean that there's a really an elongated process out there. One other feature is that you can challenge cases that where the only issue is a disclosure, where there's a question about the sufficiency of a disclosure. And if a case is limited to that, that is the same as other Swift cases, except for you can get a a less expensive filing fee, and you can bring the challenge without a letter. You can fill out a form and just point us to to the problem, which may even expedite the process in that sense. So Annie, talk a little bit more about compliance.
Sure. Compliance cases in Swift are also speedy. The advertiser's response is due in 5 business days versus 10 business days in a standard or complex track case. We also have reporting channels with platforms such as Meta and Google, where there is a referral of the matter to a government agency, typically the FTC. We also report the non-compliant ads through those channels where the ads appear on the social media platforms or on Google, or where there is continued non-compliance. I mean, there are some cases where we have multiple compliance cases, in which case we would refer those ads to the channels so that they could be taken down as quickly as possible. There's also no monitoring cases through Swift, only competitor challenges.
So next, we thought we'd talk about some of the cases we've seen in Swift to give everybody a sense of um, the various issues that pop up and maybe the kinds of cases that may be appropriate for Swift, or touch on some of the important issues we see overall at NAD. So recently we had a case involving Verizon's Frontline service, which is a network for first responders. So first responders get priority through this network in emergencies. The claim challenged was Verizon's Frontline is the network that truly prioritizes first responders. And the single issue that NAD looked there was whether or not this conveyed a message of exclusivity, in that, do the other providers not prioritize first responders? And in fact, they do. But NAD said that this did not convey a message of exclusivity in this particular advertising. So I also wanted to highlight this example because it is a case where the advertiser prevailed. And when an advertiser faces a Fast Track Swift challenge, they can be assured that NAD gives it the same care and attention and consideration to the issues, and will make the appropriate recommendation in the case, and that an advertiser is not disadvantaged just because a case is Swift and involves the single issue on an expedited timeline. We also sometimes see cases where there are allegations that product or service is disparaged. A competitor will bring a challenge, and we've seen those in Fast Track Swift. We saw one recently involving Tempur-Pedic and Sleep Number beds. Sleep Number challenge claims made by Tempur-Pedic in advertising, and there we said that Tempur-Pedic stepped over the line in portraying the Sleep Number beds as being cheap and flimsy because they, unlike Tempur-Pedic's beds, the mattresses have inflate. So it was not fair to compare them to kind of a cheap air mattress or a balloon, and they weren't quite that comparison was not a supported comparison there. So there you had a limited issue of where the extent of the disparagement, and in a little bit of advertising uh, conveyed through social media.
So these next two cases that I'm going to talk about are number one claims with respect to sales. So the first case was a challenge by Lasco against Dreo, and these were claims that Dreo was the number one fan and heater brand in the United States. Dreo argued that its number one claim was narrowly tailored, and accurately stated and explicitly limited to specific retail channels and timeframes. But we did not agree, finding that this was actually a very broad claim that applied to all channels, including brick and mortar, which was not supported. And even though they had a disclosure, regardless of whether it was sufficient, it can't contradict the main claim, so it had to be discontinued. We did say that they could make sales claims so long as they were supported. The next case is a challenge that was brought by P&G against Perigo for Perigo's Plackers Flossers product. And Perigo was making the claim that it has the number one brand of flossers. In this case, it was undisputed that P&G's Oral B was the number one dental floss product on the market. P&G's concern, rightfully, was that there's no flosser category in the Nielsen data, and which showed that for dollar sales and for unit sales, that Oral B was number one. Now there was now in terms of what the flosser is, the Perigos product, it's basically a plastic. There's a pronged fork with floss between the two tines of the fork, and there are different types of sort of flosser like products that both that P&G also markets, like kind of like the floss pick, etc. And what we said was that what the advertisers products are sort of like a portion of that product, but regardless, the number one brand claim is a very strong claim, and it's typically supported by unit sales. Now the advertiser claimed that based on IRI equivalized data that it had more unit sales of its flosser product than the Oral B for its dental pick. And what they were saying is that, hey, our products are, sold in bulk, right? So it's like 90 picks per in a package. NAD ultimately agreed with P&G and found that the number one brand claim was unsupported, and recommended that it be discontinued. This claim, the advertiser appealed this to the NARB, and the NARB affirmed NAD's decision.
So, also recently, we had another case, and this was also a telecom case where the advertiser did prevail. And this involved T Mobile and their claim that T Mobile is the first and only U.S. wireless provider to keep you connected in places never thought possible with the world's largest satellite to cell constellation in partnership with Starlink. So the allegation here was that T-Mobile was making a claim that it's the first provider to have any kind of a satellite service. But really, NAD said here that this was a claim about the partnership with Starlink, that they were the first to have a partnership with Starlink to do this, to provide this service. So we had another case where the advertiser did prevail. Another case I wanted to highlight was from last year, and this involved Bear Paints and a display they had put up in stores comparing their paints to their competitors, showing uh, various types of paints in a chart format. And it came with the claim that there was no comparable product. Um, in this case, the advertiser voluntarily discontinued the claim permanently. That is often a good thing to see because NAD makes no determination on the merits. It's a clean resolution of the dispute and happens in the expedited timeline.
So, continuing on the oral care theme from just a little while ago, we also reviewed claims by Guru Nanda against Oral Essentials for their enamel safe claim for the Lumino oral mouthwash. The advertiser submitted a study that it claimed to be the gold standard for support, specifically a 30-day scanning electron microscopy study on the effects of the use of lumino whitening mouthwash on enamel tooth chips extracted by oral surgeons, and the control was water. And to assess whether it was safe to use on tooth enamel. And there were visual assessments that were conducted by the advertiser's expert who concluded that there was no enamel damage. In this case, the enamel safe claim was juxtaposed against a clinically proven claim, and those claims are held to a higher standard of proof, specifically competent and reliable scientific evidence. The advertiser did not provide any evidence to explain why a 30-day in vitro study can be extrapolated to a general unqualified claim of enamel safety. So we recommended that the claim be discontinued. This is a bit of an older case, but it highlights some interesting ratings and reviews claims. And so this was for the Per Se Beauty's Pros Hair Care product reviews. And this was initially started off, I'm going to spare you the complicated procedural history, but it did start off as a Swift case brought by a function. Eventually, this case was reopened during a compliance review. Now, the key takeaway here is that a modified version of the 5-star reviews claim that we initially recommended be discontinued was ultimately found to be supported in the reopened case because they corrected for the flaws in the survey in the underlying Swift case. So the modified claim, which was 225,000 5-star reviews on Review and Refine, which is basically a way for consumers to review their product, and the advertiser would then make changes to their product based on the feedback from the consumer so that the consumer would ultimately give a 5-star rating. And we found that that claim was supported based on the questionnaire, which we found was designed in accordance with established survey protocol. Now, this, some of that was provided to us on a confidential basis, but the request for feedback was asked in a neutral manner. The review was not incentivized, and they also ensured that there were only verified purchasers. There's only one review that could be submitted per order, and there is no possibility of double counting of reviews. And another key point actually is that although they highlighted 4 and 5-star reviews, we found that that was acceptable because most of the reviews were in fact 4 and 5-star reviews. If that had not been the case, if most of the reviews, for example, had been neutral or even negative, then that would have been problematic.
So I think that recap should give everyone a sense of what we do see in Swift. And I think what you should note is that these cases are limited to the single issue as required. Sometimes there is no evidence involved, really, and it's just a question of an interpretation. Sometimes there is very straightforward evidence, such as sales data, and sometimes there is evidence that may appear to be more complex, but because of the limited scope of the issue presented, may not require a more thorough review of the evidence in its totality. So it's not that the mere existence of technical data will disqualify you from Swift. It might, and if NAD needs to make a determination that requires extensive briefing or issues that may not be apparent or may require spotting issues that are not readily apparent from on the face of the evidence or in the papers, that may not qualify for Swift. But if the evidence is such that it can be reviewed in the timeline, and limiting to the and limited to the single issue, may be appropriate for Swift. And that's a case by case determination. So Swift is now a fixture at NAD, but it is still evolving, and we understand that there are questions about whether cases are appropriate for Swift. We get them all the time, and we are open. We have our Swift is now a fixture at NAD, but it's still evolving and has evolved over time, even in the 5 years that it's been around. For instance, implied claims were not permitted in Swift at the outset. Now they are if they still fit within the single issue framework. And as we understand that this is evolving and still somewhat new at 5 years, we always feel free to reach out to us for guidance and feedback. So just to wrap everything up, I think one takeaway we have here is that just because a case involves a single issue doesn't mean that it's not an important issue. Um, we get cases that in Swift that are parts of high profile campaigns, Super Bowl ads. We can hear them in Swift if they do qualify for that as being appropriate for Swift and presenting that single issue that won't require the review of complex evidence and arguments such that it can't be resolved in 20 business days.
Another thing is, ask yourself if this case is right for Swift. Is it really a discrete issue that doesn't require a complex substantiation? It's not always so clear. So I think it's very important for you to be aware that the advertiser can object and try to move the case out of Swift into standard or even complex track. Now, that ultimate determination is up to NAD, but certainly, when before you even submit your case, really try to make sure that this is appropriate for review in Swift, and that if there is an objection, hopefully that NAD will rule in your favor, and then the case can continue in Swift.
And just in closing, I wanted to say that Swift, it's an example of how self-regulation can work and some of the advantages of self-regulation that as an alternative to litigation, uh, that it provides for expedited review of certain issues that may qualify. We're coming to our end here, and thank you again for tuning into this episode of The Ad Watchers. We hope you enjoyed it.
Join us next month for another episode of The Ad Watchers. As always, you can head over to our website, bbbprograms.org, to learn more about what we do at the National Advertising Division or any of our other self regulatory programs. That's all for this episode. See you next time.
Thanks again for tuning into Ad Watchers. Be sure to check out our previous episodes at accountabilitystudio.org, Apple Podcasts, or wherever you listen to your favorite podcasts. And don't forget to subscribe to get notified about our next episode.